This is Jackie Schollerman with Coldwell Banker here in downtown Palo Alto. I would like to introduce you to Kay Carey, a prominent family law attorney here in downtown Palo Alto. So Kay, tell us, what are the newest law pertaining to family law, and also what are the frequent issues that you encounter that you would like to share with our viewers?
Good afternoon, people. My name again is Kay Carey, and I'm here to kind of give you a basic introduction to California family law, which really means a dissolution of marriage proceeding, which is used to terminate the marital relationship. Any of you who are married are very familiar with the process of obtaining a marriage license. When you've arrived at a point in your marriage where one of the spouses, it does not have to be a joint decision, decides that the marital relationship has broken down, cannot be repaired, that spouse can decide to terminate the marriage. While there are many different ways to accomplish that end, what the California court system is doing is making it possible for the one spouse to be able to say, I want the marriage to be over. And when this is done, that spouse will typically file a petition for dissolution of the marriage. What the court is concerned about is, first of all, the termination of the marital relationship, which normally that's what the court will do. The earliest the actual termination can occur is 6 months from the date of the appearance of the other spouse or valid service of process. The court then is charged with the responsibility of determining, are there any children of the marriage? Is there any property of the marriage? What kind of disputes should be brought to the attention of the court? And they tend to fall in the area of child and spousal support, of child custodial orders, of division of community property, a confirmation that certain property is separate. And we will also be looking at any possible reimbursement claims. And those are the types of disputes that a court is willing to entertain information about and make a decision. The parties are free on their own or through their acknowledged agents, such as their attorneys, to make an agreement which, if it is fair and equitable, will be approved by the court. And the actual agreement should cover these issues so that the court knows that, yes, we have disposed of all community property. Community property is a term that is used in 11 of the United States, and that's because they are known as community property states. Other states are separate property states. An example might be New York, where your earnings are separate. What you accumulate is separate unless you title assets jointly. That is not the situation in California. Our community property comes from the Spanish heritage, and that is used as the basis of getting married is a sacred obligation, and so that means our earnings are joint and not separate. And from that decision that all of your earnings are joint, that is how we've derived community property law. Because if you use your earnings to acquire an asset, it will be considered joint up to the date of division. That's what we mean by community property. People can vary it by agreeing in writing that that is not true and stating reasons. Typically, if they want the agreement enforced, it is better practice to use their own attorneys in devising that property agreement. But if they have not made a property agreement, the court will apply the law. The same thing happens with children, which can cause a variety of disputes in the family law area. That's why there is a need for custodial orders. What we assume in California is that both parents are equally capable of parenting children. and the courts try, whenever possible, to use a 50-50 division of time. Sometimes it's simply not possible. People live too far apart. Either spouse has the constitutional right to live wherever a spouse so chooses. The obligation of the court is to decide whether or not the children get to relocate with the moving spouse. What is a reasonable visitation plan? That is what we mean by custodial disputes. And the court is the final decision maker if the parties are not able to agree. The court may use experts to help the court fashion its opinion. And by the court, I am always referring to the decision of the judge. In California, in Northern California, we use a system where a particular judge is assigned a case and keeps the case as long as that judge is in the family law division of the Superior Court. The actual venue is where the parties reside. Let's say that the parties live in two separate counties. Then it will be the question of, well, who filed first and who served the other spouse. Instead, the parties say, well, we're going to jointly negotiate. Courts encourage this. You always get or almost always get a better result if the parties, through their agents, can make an agreement. And as I said, the agreement will be focused on what are my property rights, what is the other spouse's property rights, what are our rights and responsibilities to support the other spouse. That is what we mean by spousal support. Or what is my right or responsibility to support my children? And looking at the children, you are making a decision on where do the children live, in which county, do they share time, do they have a visitation plan? Maybe instead they have a parenting plan where each parent is mutually responsible for seeing that the child is raised. Again, there are many, many disputes in this area. They can lead to hard feelings. Kids have sometimes been used as messengers, strongly disapproved of by the courts, because we would much prefer to see that the parents as adults work out these decisions and use experts if they need to, because they can't really figure out what to do. In addition, we tend to set support obligations by how much money does each parent make. In general, both parents now work. It used to be a lot of women had to stay home and in fact were not employed at full capacity. And so the usual pattern had been women raised children and men made money. That is not true now. Women hold many responsible jobs. We also know and have learned from essential workers that many Californians do not make a lot of money. And then you have the problem of, well, how are you going to divide a tiny pot into what are now two households? And these are very difficult and intractable problems. We also find problems when people have a great deal of money because it can be wasted in fighting. So that's why I'm urging you all to see if you can't work cooperatively with your spouse, because you will normally get a better outcome. Sometimes one parent or one spouse is taking an absolutely unreasonable position. That is why we have a court system. That means you do have a place where you can go and you can have your side of the story be heard and considered. And if you have good evidence, such as written memorabilia, objects that have been bought, things that have been done, recordings that you've made. Now we're in a social media age and people leave many footprints of what they've been doing. So you do have a way to get evidence, and you do have a break on one spouse exerting too much pressure and power. And if you have to resort to the court system to get that type of pressure stopped, that's one reason for the court system to exist. The other reason, though, is that the court system actively encourages people to negotiate and to try to remove as many of their conflicts as they can from the court system so that the court is really dealing with the very messy, intractable problems, and the parties are working out more garden variety disputes without needing the assistance of the judge. Many people have the common experience of needing to get into court because of the need for spousal support, or child support. Maybe the children are all living with just one parent and the other parent is only visiting. And so many people will go into court at the outset of a dissolution proceeding to have the support rules established by the judge. They tend to be more pro forma and standard at the beginning so that the parties know what they're going to be in for. Doesn't mean it can't vary by the time you're ready to make your overall settlement. It simply gives people some financial rules at the beginning. Also, if people have a problem agreed on what is a reasonable custodial arrangement, the court will again oblige, even though it takes several months, to do a mini investigation to say, well, as a temporary matter, people should be willing to live with these following guidelines. And people might alternate a week on, a week off on visitation. They might be on what we call a 2-2-5 plan or 2-2-3 plan, meaning every 2 or 3 days or 2, 2, and 5 days, the children will be residing with one parent and then the other. In these times, at the beginning of a dissolution, sometimes people cannot afford to leave the family residence. And so they will set up these very strict rules of where parties can be in the same residence, with the understanding that one or the other of the spouses will be moving out at a date in the future, so that this is considered a temporary arrangement, not that each spouse has an absolute right to live in the same piece of real estate. And this can help people adjust to being in new circumstances because the two parties can no longer live together. I hope that this gives you a brief outline of how the court system can be helpful to people. We did experience COVID-19 in the family law system because all of our courts were shut down in March. And unless you had an absolutely immediate emergency, meaning something where one party or the other was at the risk, or the children were at risk of being physically harmed, more than just emotional injury, there was a real threat of physical violence or actual harm occurring, the courts made themselves available, even though they had very few clerks, very few assistants, and it was very difficult navigating. And in fact, it was only a few months ago that our local court system, meaning San Mateo County, Santa Clara County, Alameda County, San Francisco County, all of the Bay Area counties, each has their own superior court system, but the rules are remarkably similar, so that when the courts were able to say, we've always been open for filings, it was just hard to get the actual attention of the judge or the court-appointed experts. We've now made arrangements where, in addition to filing, we can now actually have appearances in court if necessary. We also can file motions, submit briefs, make arguments, and do the things that we used to be able to do. It's just they're a little more cumbersome, and it's always remotely done. The courts still do not encourage you to physically attend. They would rather have you attend electronically because it's safer for everybody. Mm-hmm. And so that's why, while cases were getting processed at a glacial pace months ago, the pace has now picked up. But nonetheless, if you need help from the court besides emergency clearance, you will be waiting months for your court date. It is not quick the way it used to be. We're all hoping that it'll revert back to what it was, but as with everything with COVID-19, it's kind of hard to tell. So I just want to let you know, if you're thinking about getting a divorce, yes, relief is available. You can I always recommend people use attorneys to at least find out what their rights are and what their responsibilities are, so they have some knowledge of how the law might be applied in their case, and then they can plan accordingly. Thank you. It's very nice to talk to you.
Well, great. Kay, this was extremely valuable and very informative. So for the viewers who want to get hold of you, what is the best way to contact you?
The best way is either you can call our law firm, and that number is 650-328-5510. You can email our law firm, and you can email individual attorneys at our law firm. Like my email address is the initials KC at Carey and Carey Law. That's CAREYAND, CareyLaw.com. And my assistant can always be reached at admin at Carey and Carey Law.
And you're in downtown Palo Alto in California.
Yes, we're at the corner of Cowper and Forest. We're in the White Victoria, and we're very happy here. We've been here since 1978.
Wow, that's remarkable. Wonderful. I've been to your office several times, not for divorce, but for visiting you. And thank you so much for sharing this valuable information. I'm sure there are several families, unfortunately, may have to go through the separation as you indicated, and I'm sure they will be reaching out to you.
Well, Jackie, I'm just glad to give your clients as much information as possible.
Thank you so much.
Thank you.